Moments ago, the Justice Department moved to drop the criminal charges against the former Olympian accused of vandalizing the reflecting pool on the National Mall. Prosecutors admitted the $14 million installation was rushed and flawed. Joining us now is CNN's Caitlin Polantz and CNN senior legal analyst Ali Honig. Caitlin, let's start with you. This is a big admission by the Justice Department.
A big admission on two fronts, Pam. One is that they are now saying that this pool liner, it was damaged because it was installed incorrectly. And the reason it was installed incorrectly was because the Trump administration was rushing for a pool liner to be placed on the bottom of the reflecting pool as they were awaiting the July 4th, 250th celebration on the National Mall. They wanted it to be done in time, and so it was rushed. The installation was bad, and there was damage throughout that liner that the Trump administration had on the bottom of the reflecting pool. The second admission that they're making, now that was already quite a big change in posture by the administration to admit that their installation was wrong. The second thing they're doing is they are dropping a criminal case, a felony charge against David Hearn, the former Olympic canoeist. He lives up in Maryland, very close to Washington, D.C., and he had visited the National Mall. There were witnesses the Justice Department brought into the grand jury who were park police, employees of the federal government, who had said that they witnessed Hearn tearing at that reflecting pool. He had been charged with a felony because they said the damage was so significant. It amounted to more than $1,000 that he caused. Now they're entirely reversing that and saying that after the reflecting pool was drained in recent days, the Justice Department went back to look at it. They've already indicted Hearn. They already have alleged that he was the person causing this. He was a vandal. But then they went back to look at exactly what was the bottom of that pool looked like after there was water drained from it after the July 4th celebration. And Pirro's office determined it looked like there was damage throughout. They didn't realize how extensive it was, and the Department of Interior then backed them up with some more information saying the damage was the result of a botched installation and not vandalism, not Davy Hearn's fault. We got a statement from Hearn's attorney, Norm Eisen, just a few minutes ago. He says the Trump administration's case against Davy Hearn should never have been brought. Its dismissal today does not erase the abuse of government power in arresting and charging a patriotic American who did nothing wrong. The government's approach was ready, aim, fire, and the administration owes him an apology. Pamela?
Ali Honig, what do you make of this development?
Well, Pam, I think you could see the problems with this case right away. I wrote a piece for New York Magazine. I said on air that there were some reasons to doubt the validity of this case. I did not expect it to unravel so quickly. It's a real embarrassment, first of all, for the United States Justice Department. Let's remember, first they arrest David Hearn. They charge him initially by complaint with a misdemeanor. Then they upgrade it to a felony. They get a grand jury to indict him for that felony, and then Jeannie Pirro holds a press conference where she's pounding the podium and talking about what a serious crime this is and how justice will be done. And now it turns out they dismissed the case voluntarily. And what DOJ is saying in the statement that we've received is that, well, we didn't get the full information about the state of the pool from the Interior Department until after we charge. But that's no excuse at all. It's your job as a prosecutor to get the relevant information first. You don't charge first and then figure it out. You get the information first and then charge. So it's a true embarrassment for Jeannie Pirro. It's a true embarrassment for DOJ, and they brought it on themselves.
So explain more about why it matters if the pool was already damaged or not, because the case was made before that he reached in and pulled it up and everything. What is the relevance of the fact that now they're saying, well, this wasn't the only area where it was damaged, and so therefore we're going to drop these charges?
So the actual felony charge that DOJ brought here requires prosecutors to show that the defendant caused over $1,000 worth of damage. One of the points that the defense had made is if this liner was already destroyed, then it's worthless. Then you can't cause $1,000 worth of damage. To make a rough analogy, if you already have a window that's already broken and then someone throws a rock through it, he hasn't damaged it anymore because it's already useless. So this actually doesn't even get to the point of whether David Hearn reached into the pool and ripped something up or not. Regardless, either way, they're not going to be able to show that he caused $1,000 of damage, even if he did rip it up, because now, according to the government's own admissions, the pool was already destroyed. The liner of the pool was already destroyed, and it doesn't really matter whether he reached in there and ripped it or reached in there and just touched it or did nothing at all. If you can't show the $1,000, you can't make your felony charge.
But couldn't you just go and see that it was already an issue, that it was already destroyed? Like, you don't even, I mean, I don't know. I had been down there. It didn't look so great.
A halfway decent investigation would have done just that, Pam. There obviously was a mad rush to do this case. Jeannie Pirro obviously oversold it dramatically at that press conference, and this is the consequence of that.
Caitlin, what else are you learning from the court documents?
You know, Pamela, one of the things that's happening in these court documents is there is a recitation from the U.S. Attorney's Office, Jeanine Pirro, the U.S. Attorney, the Justice Department in D.C., where they are pointing fingers at a host of other people in the government, including the government contractors that completed this work, and also the Department of Interior and others, where her office is essentially saying they just didn't realize the extent of the damage, and they didn't have documents until after they were looking at this and building this case against David Hearn. They actually say that they received documents about the installation of this reflecting pool from the Department of Interior only a couple days ago, after July 17th, when they went back to Interior. Now, that's maybe 2 weeks after Hearn was indicted. They clearly didn't have a full record at the time they indicted him, and they then walk through all of the ways that they learned that people were realizing there were issues with this reflecting pool liner as it was being installed throughout the month of May. One of the notes here was that some of this was noticed by a quality control inspector in late May who saw blistering in finished portions of the liner and said that it needed repairs at that time. That was well before Davy Hearn and others ever got to the mall to take a look at that liner coming up. They also are pointing, the Justice Department is pointing to other stuff that was happening in Washington for the 250th celebration, including at one point in this filing, she's writing, or her team is writing, of prosecutors saying that some of the equipment and the crews that were working on the reflecting pool, they had to be moved over to the White House grounds because of the UFC fight that Donald Trump was hosting there. I don't know if I've ever seen an autopsy of what was happening between branches of the government like this in a filing, just putting it out there, but it is a filing where the Justice Department, once they got this sort of information, would have needed to come clean because the evidence just wasn't there to prosecute Davy Hearn for felony vandalism.
And Ellie, you noted this, that U.S. Attorney Jeanine Pirro came out strong when announcing the charges earlier this month with that press conference. I want to play a little bit of what she said.
There was an effort, a violent effort, to rip up the sealant from the bottom of the pool. We can state and prove beyond a reasonable doubt that he caused damage, and that damage is over $1,000.
Keying in on that, how do you prove that $1,000?
With an expert.
Is that because
come to the trial.
Did he have any tools, or was it just his bare hands?
Right now, we believe it's his bare hands, both hands.
So does that indicate in your belief that it was probably damaged before, or do you believe that he had
He damaged it.
further, but do you believe it had already been damaged before?
He damaged the pool.
Before he touched it?
He damaged this pool.
But there have been, all these videos, obviously.
Well, good. I'm glad you've got that evidence. Come on in the grand jury. You can testify. Next.
Ellie, what's your reaction?
Okay, this is how not to prosecute 101. First of all, do not hold a press conference for a nothing little case. Second of all, do not overstate your evidence. And third of all, to the point that Caitlin just made, do your work first. Do your investigation first. It's ridiculous now that the U.S. Attorney's Office is saying, well, it's Interior's fault. Well, it's this person's fault. Well, it's that fault. We didn't know this. They didn't tell us that. That's your job as a prosecutor. You don't charge a person with a felony, which could have locked him up. The max here would have been 10 years had he been convicted. You don't charge a person with a felony until you know what you're talking about. And if Jeannie Pirro thinks that it's somehow taking blame off her office to say, well, there's all these other things out there that we weren't told, she's wrong. She's actually putting the blame on herself because they didn't know this stuff. They didn't figure out before they indicted. That's how they should have done it.